Breaking news like this doesn't just shake the legal world, it sends shockwaves through millions of American gun owners overnight. A new wave of legal interpretations following a 2026 Supreme Court order is triggering massive debate about what firearms could suddenly become illegal in certain states and which ones are standing stronger than ever against federal regulators. Across gun forums, legal circles, and state legislatures, one question is dominating the conversation: which guns are now at risk, and which ones remain effectively untouchable by the ATF. For decades, firearm laws in the United States have existed in a complicated balance between federal regulation, state authority, and constitutional protection. Every time the Supreme Court issues a major ruling related to the Second Amendment, that balance shifts. Sometimes the change is subtle, other times it forces states and federal agencies to completely rethink how they regulate firearms. The ripple effect from the latest legal developments in 2026 is now beginning to reveal a clear pattern. Certain categories of firearms are facing increasing legal pressure, while others appear more protected than regulators anticipated. The reason this matters so much is because the Supreme Court does not typically write detailed gun regulations itself. Instead, it defines the constitutional limits that lawmakers and regulators must operate within. When the court clarifies how the Second Amendment should be interpreted, every lower court in the country must adjust its legal reasoning accordingly. That means regulations once considered acceptable may suddenly face constitutional challenges, and restrictions that seemed secure can begin to collapse under judicial review. In recent years, courts have increasingly relied on a historical framework when evaluating firearm regulations. Instead of asking whether lawmakers believe a restriction is reasonable, judges are now examining whether similar restrictions existed during the early history of the United States. If a modern regulation cannot be justified by historical precedent, it may struggle to survive constitutional scrutiny. That shift alone has dramatically changed how firearm laws are evaluated. This is where the confusion begins for many people. Some firearms that regulators tried to restrict under modern interpretations are now facing serious legal challenges because courts are demanding stronger historical justification. At the same time, certain firearm categories that lawmakers previously assumed were protected are now being examined more closely based on how they fit within historical traditions. The result is a legal environment where some guns appear increasingly vulnerable to restrictions while others are becoming more secure than ever before. One of the most controversial areas involves rifles that lawmakers classify as modern tactical firearms. These rifles have been at the center of regulatory debates for years. Some states argue that their design features place them outside the category of traditional firearms protected by the Constitution. As a result, lawmakers in several states have pushed forward with restrictions targeting these models, claiming they represent a newer class of weapon that should be treated differently under the law. Supporters of these restrictions often focus on features such as detachable magazines, adjustable stocks, or certain cosmetic design elements. Critics argue that these features do not fundamentally change how the firearm operates and that banning them amounts to regulating appearance rather than function. Courts reviewing these disputes must now determine whether such distinctions have meaningful historical support. If they do not, some of these bans could face significant constitutional challenges. However, the legal picture is not identical across the country. In some states, lawmakers have moved quickly to implement new restrictions in anticipation of future court battles. These laws may ban the sale of certain rifles, limit their transfer between owners, or require existing owners to register them with state authorities. Even if those laws eventually face legal challenges, they can still create immediate consequences for firearm owners in the short term. Another category drawing attention involves firearms with large-capacity magazines. For years, several states have attempted to restrict magazine capacity by limiting the number of rounds a firearm can hold. These laws have been the subject of intense legal debate because magazines are integral components of many commonly owned firearms. Courts reviewing these restrictions must decide whether such limits are consistent with constitutional protections or whether they represent an overreach that infringes on lawful ownership. Some courts have upheld these restrictions, while others have struck them down, creating a patchwork legal landscape across the United States. The latest wave of Supreme Court interpretations could eventually push the legal system toward a more unified standard, but until higher courts resolve those disagreements, the legality of certain magazine configurations may continue to vary depending on where someone lives. Handguns have also entered the legal spotlight, although in a different way. Unlike some rifle categories, handguns have consistently been recognized as one of the most commonly owned types of firearms in America. Millions of citizens rely on them for lawful purposes such as personal defense, Because of that widespread use, courts have often treated attempts to ban handguns with extreme skepticism. Many legal experts believe that broad handgun bans would struggle to survive constitutional scrutiny under the current legal framework. That does not mean handguns are completely free from regulatory attention. Some states have introduced rules concerning handgun accessories, licensing requirements, or specific design elements. These regulations are frequently challenged in court, where judges must determine whether they align with historical firearm regulations or represent modern inventions without constitutional grounding. Shotguns occupy another interesting position in the legal landscape. For much of American history, shotguns have been strongly associated with hunting and sporting activities. Because of that tradition, they have generally avoided the intense regulatory battles surrounding other firearm categories. Nevertheless, certain modern shotgun designs have begun attracting attention from lawmakers who argue that some configurations resemble tactical firearms more than traditional hunting tools. In a few jurisdictions, proposals have surfaced targeting shotguns with detachable magazines or tactical styling. While these efforts are not as widespread as restrictions targeting rifles, they demonstrate how evolving firearm technology can blur traditional legal categories. Courts reviewing these proposals must determine whether such distinctions hold up under constitutional scrutiny. Despite these ongoing debates, several firearm categories appear to be on very solid legal footing. One of the strongest factors courts consider is whether a firearm is widely owned by law-abiding citizens for lawful purposes. When millions of Americans legally own a particular type of firearm, it becomes much more difficult for governments to justify banning it outright. This principle has repeatedly appeared in court rulings analyzing the scope of Second Amendment protections. Traditional semi-automatic pistols fall squarely into that category. These firearms are among the most commonly owned defensive weapons in the country. Because of their widespread use and historical acceptance, they enjoy strong constitutional recognition in many legal decisions. Attempts to ban them entirely would likely face serious legal hurdles. Classic revolvers also remain deeply embedded in American firearm culture. These handguns have existed for well over a century and have been widely used for self-defense, law enforcement, and sport shooting. Their long-standing presence in American society makes them difficult targets for modern regulatory bans. Courts reviewing firearm laws often consider such historical continuity when evaluating constitutional questions. Bolt-action hunting rifles represent another category that appears extremely secure. These firearms have been staples of American hunting traditions for generations. Their design is simple, their purpose is widely recognized, and their lawful use is deeply connected to cultural traditions across rural America. Because of that history, they rarely appear in modern regulatory debates compared to other firearm types. Lever-action rifles share a similar legacy. These firearms have existed since the 19th century and remain popular among hunters and collectors alike. Their long-standing place in American history provides powerful context when courts analyze whether modern regulations align with historical firearm practices. What makes the current legal moment so fascinating is how these historical considerations are shaping modern legal battles. Judges are no longer simply asking whether lawmakers believe a regulation might improve public safety. Instead, they are examining whether similar regulations existed during earlier periods of American history. If no historical equivalent can be found, modern restrictions may face significant constitutional challenges. That historical approach is transforming how firearm laws are debated in courtrooms across the country. Legal teams now spend enormous effort researching historical statutes, early American legal traditions, and centuries-old regulations. Those historical records are becoming key evidence in determining whether modern gun laws stand or fall under constitutional review. For federal regulators like the ATF, these developments create a complex challenge. Agencies must enforce existing laws while also adapting to evolving legal interpretations from the courts. When judicial rulings redefine the limits of regulatory authority, agencies may need to revise enforcement policies or reconsider how certain rules are applied. That process can take time, which sometimes leads to periods of uncertainty while legal questions are resolved. Gun owners, meanwhile, are watching these developments closely. For many people, firearm ownership is not only about self-defense but also about sport shooting, hunting traditions, and collecting historically significant firearms. Changes in the legal landscape can affect how these activities are practiced, which is why major court rulings attract so much attention. Another factor influencing the debate is the difference between federal and state authority. Even when federal courts clarify constitutional principles, states still retain significant power to regulate firearms within their borders. That means the exact legal status of certain firearms may vary depending on where someone lives. A firearm that is legal in one state might face restrictions in another, creating a complex regulatory patchwork. Over time, some of these differences may be resolved through additional court rulings. When legal conflicts between states reach higher courts, judges often step in to clarify how constitutional protections apply nationwide. Until that happens, however, the legal landscape can remain complicated for both firearm owners and lawmakers. Legal scholars often describe this process as the natural evolution of constitutional law. Major Supreme Court rulings establish broad principles, but it can take years for lower courts to apply those principles to specific situations. Each new case helps refine how the Constitution is interpreted in practice. The current wave of firearm litigation is part of that larger process. What makes the current moment particularly significant is the scale of the debate. Firearm ownership touches on questions of constitutional rights, public safety, historical tradition, and cultural identity. As courts continue examining these issues, the outcomes could shape the legal framework surrounding firearms for decades to come. For people trying to understand these developments, the key takeaway is that firearm law in the United States is constantly evolving. Court decisions, legislative actions, and regulatory interpretations all interact to shape the final legal outcome. What appears uncertain today may become clearer as future rulings provide additional guidance. At the same time, the principle at the heart of the debate remains the same: how to balance constitutional rights with the authority of governments to regulate certain activities. The Supreme Court's role is to define the constitutional boundaries of that balance. Once those boundaries are established, every other court in the country must operate within them. That is why the 2026 legal developments are drawing so much attention. They signal another turning point in how the Second Amendment is interpreted and applied. Some firearm categories may face increasing legal scrutiny, while others could become more protected than ever before. The full impact of these changes will likely unfold gradually as new court cases test the limits of existing regulations. Each ruling adds another piece to the puzzle, shaping how firearm law develops across the country. For now, the debate continues, and millions of Americans are watching closely as the legal landscape evolves. And as these legal battles move forward, one thing remains certain: the future of firearm regulation in the United States will not be decided by a single law or a single court decision. It will emerge through a long series of rulings, debates, and historical interpretations that ultimately determine which firearms face restrictions and which remain firmly protected under the Constitution.